Hi there. My name is Matthew Noyes. I'm a workers' compensation attorney here in Clearwater, Florida. We have offices throughout Tampa Bay, and we have been helping fight for workers' compensation benefits for the injured workers for decades. In this video, I wanted to talk about what wage benefits an injured worker would be entitled to. But before we can talk about wage benefits, we have to talk about the average weekly wage. The average weekly wage is what we look at when we try to calculate what the indemnity benefits would be, or the wage benefits you would be entitled to if you get hurt at work. The AWW, or the average weekly wage, is calculated by looking at the 13 weeks prior to your work injury, figuring out all the income that was earned, all the fringe benefits that were no longer being paid, and then dividing that by 13. That would be the AWW. Seems easy, but there are many situations where the injured worker may not have a clean 13-week wage statement. They may have only worked a week or 2 weeks before they got hurt. It may be a seasonal employee. There are situations where we need to look to the statute in order to properly calculate the AWW. For example, if the injured worker only worked a few weeks before they got hurt, they may look for a similar employee who worked the same schedule and the same rate of pay, and use that person's average weekly wage to calculate the average weekly wage of the injured worker. Once we know the average weekly wage, then we can calculate the compensation rate. The compensation rate is 66 2/3 of the average weekly wage. Why is that important? Because if a doctor places an injured worker out of work, totally out of work, can't go back to any work because of the work comp injuries, they would be entitled to temporary total disability benefits, TTD. If they are entitled to temporary total disability benefits, they would be entitled to the compensation rate, or 66 2/3 of the average weekly wage. That's why it's important when we calculate the AWW, we want to make sure it's as high as possible, because the injured worker gets 66 2/3 of the AWW. But it's important to understand that it has to be the authorized workers' compensation doctor that takes the injured worker out of work. If it's a family doctor, workers' comp doesn't have to follow those restrictions or those guidances. It has to be an authorized treating doctor under workers' comp in order to be entitled to temporary total disability benefits, or 66 2/3 of the AWW. But let's say the authorized treating doctor doesn't take you out of work altogether, but says you're on modified duty or light duty. That's where temporary partial disability comes into play. There's two scenarios. There is restricted work available for you, or there's not. First, let's talk about if there is restricted work available for you. For example, I had a situation where a garage door installer got hurt at work. All he did was install garage doors. He got hurt at work, and the authorized treating doctor says, well, you can't install garage doors, but you can do something that has lifting less than 10 pounds and no bending and stooping and such like that. Well, the employer had work available for him in the office. He was filing papers, he was making phone calls and such like that. That is the light duty work, or the restricted work, that the injured worker has to do. If they refuse to do it, they would not be entitled to temporary partial disability benefits. So they don't have to be paid what they were being paid installing garage doors. The employer could say, listen, I got remodified duty for you, but we're going to pay you minimum wage. The injured worker cannot refuse that. If they refuse it, they wouldn't be entitled to temporary partial disability benefits. But how are temporary partial disability benefits calculated? What you have to look at to determine whether or not an injured worker is entitled to temporary partial disability benefits, or TPD, is you have to look to see if they return to the modified duty, whether or not they earned 80% of the average weekly wage. If they earned 80% or more of the average weekly wage, they would not be entitled to temporary partial disability benefits. However, if they did not earn 80%, then they may be entitled to temporary partial disability benefits. What they look at is see how much did you earn on restricted duty and what was 80% of the average weekly wage, and then workers' comp has to pay you 80% of that difference. A little confusing, but let's put it into an example. For example, let's say that for simple purposes, let's say the AWW is $100. And somebody gets hurt at work and the doctor places them at modified duty, and the employer says, I got work for you, but we can only pay you $50 a week. Okay, so he goes back to work, he earns the $50 from the employee. Is that 80% of the average weekly wage? No, 80% would be $80. So there's a $30 difference between 80% and what he earned. Workers' comp has to pay 80% of that $30. That's why it's sometimes called 80% of 80%. And the same situation holds that if the employer does not have restricted work or limited work available within the restrictions and limitations imposed by the authorized trained doctor, you do the same calculations, but the earnings is zero. So if the injured worker says, here's my restrictions, I'm ready to go to work within these restrictions, and the employer says, I have no work available for you, what's the earnings? The earnings zero. So they look at 80% of the average weekly wage minus what the employee earned, which would be zero, and they have to pay 80% of the 80%. Things to remember for temporary partial disability benefits is that if the employer has work available for you, you have to try it. Stay within the restrictions and the limitations that the doctor has assigned to you. If the employer tries to have you do more, report it to a supervisor, but also report it to the authorized treating doctor so they can document whether or not other restrictions should be imposed. So you get temporary total and temporary partial disability benefits. Those benefits are payable until the injured worker reaches maximum medical improvement. We'll talk more about maximum medical improvement, or MMI, in the medical video, but MMI really means that the doctor says you're as good as you're going to get. You're done with remedial care. You still may need palliative care, but you're as good as you're going to get. At that time, these benefits, temporary benefits, end. Whether you're at work or whether you're able to go back to work or not, these benefits end. So that's why we never want to push maximum medical improvement. We want to get you as good as you can get until these benefits end. But once these benefits end, unless you're entitled to permanent total disability benefits, your wage benefits end, even if you're not able to return to work. There is a little something called impairment benefits that you are entitled to. It's not really wage benefits, but they are benefits that are paid based on the percentage of impairment that the authorized treating doctor assigns to you. There's a Florida impairment guide that the doctors have to follow, and they look to see what your restricted range of motion are, or what other procedures you may have done, and they calculate a percentage of disability or permanent impairment. And based on that percentage, you get impairment benefits. Impairment benefits are paid 2 weeks for every 1% of impairment, up to 10%. If your impairment rating is higher than 10%, you get additional weeks for those additional impairments. How much is paid? 75% of the compensation rate is paid under impairment benefits. That is, unless you're working. If you are working, then it's 50% of the 75% of the compensation rate. I know math wasn't supposed to be in law or in workers' compensation, but that is what we deal with on a daily basis. So the wage benefits end if you're not permanently and totally disabled once you reach maximum medical improvement. But if you reach maximum medical improvement and your impairments or your injuries prevent you from returning to any type of work, then you may be entitled to permanent total disability benefits. Permanent total disability benefits will pay you your compensation rate every week until you reach the age of 70. However, in order to be entitled to permanent total disability benefits, you have to prove that there is no work available for you and your injuries from the work comp accident prevent you from returning to even sedentary work. It's a tough threshold to meet, but not impossible. With the proper medical documentation, you can fight for permanent total disability benefits. I hope you found this helpful. The wage benefits that an injured worker would be entitled to vary depending on where you are in medical treatment and what restrictions and limitations the doctor gives to you. If you have any questions regarding workers' compensation wage benefits, please give us a call. Again, it's Matthew Noyes. You can email me at matt, usalaw.com, or you can call us at 727-796-8282. I wrote a book about the rights and responsibilities that an injured worker has after a work injury. If you'd like a free copy of my book, just send me that email at matt@usalaw.com, and I'll be happy to send one out to you. I hope you found this video helpful. Take care, and good luck.